be something that's going to be overcome. But the law is very clear that the remedy for that is, of course, an effective voir dire process. And we put together a good procedure last time. It was very efficient. It worked, even though the frenzy was out there then too. I want to be clear that I'm here to be reasonable because as I said before, I want to pick a jury that win, lose, or draw will stick, and that we have a fair to both sides. And I believe that we can do that. But the issue, of course, is not pretrial publicity. Long gone are the days where people got their news from the evening paper or the morning paper, and it is ubiquitous out there. So we're going to have to rely on our citizens and identify those citizens who can put whatever they may have heard aside and honor their oath to be fair and impartial. I also want to be reasonable here when I say that I'm happy to consider any other option, but I also am a steward of the taxpayer money, and the statute also requires the least logistical expense. I also, as I said before, we didn't let court break down for 6 weeks, and it was a logistical, huge effort that I give credit to a lot of these staff members back here in keeping one witness coming up after another to get this thing going. And so I'm thinking about those things, and I have been in court. I love Charleston. Charleston's one of my favorite places in the world. I have been to court down there many a time, and it is always a logistical difficulty. And to contend it's not the most expensive city in the state, I don't know what to say to that. So I have to at least not be, when the defense says Charleston or nothing, I have to at least say, Your Honor, there's problems with that, and we believe that there are other choices in the state that would be better, of which I am happy to talk about and consider those other choices. That's been the state's position. In the end, Your Honor, all I want is a fair jury to the state and to the defense, and have us be able to present our case to citizens who are going to abide by their oath and be fair and impartial to both sides. And that's the process that we're looking to have happen.
Okay, thank you. Anything else from the state?
Defense?
I mean, defense. I'm sorry.
I have so much to say, but probably not. Thank you, Your Honor.
Thank you, Mr. Harpillion. All right. I understand. It sounds to me like y'all are just agreeing to disagree. Y'all just want, each one of y'all want a different place to hold it. But let me tell you, I've read your motions, and I took them seriously and went through and did some work on them. And I'm gonna tell you, after reviewing the motions submitted by both sides, I even went back and looked at the transcript of the jury selection that was conducted back in January of 2023, and also the opinion from our Supreme Court. I'm going to order that venue be transferred to a county outside of the 14th Judicial Circuit, because I believe that the defendant cannot receive a fair and impartial trial in Colleton County. I'm making this ruling in pursuant to the South Carolina Code 172180, and it's supported by case law. That would be State v. Law, where the circuit court retains the power to transfer venue outside of the circuit where a fair and impartial trial cannot be had. So I'm transferring it not only from Colleton County, but out of Colleton County completely. I find that the defendant has satisfied his burden under State v. Manning, where he's demonstrated actual juror prejudice. And unlike the ordinary pretrial publicity case, the evidence before this court is based on the actual results of the voir dire conducted in this case in the January 2023 trial. Fewer than 1 in 7 prospective jurors were qualified to serve, demonstrating an extraordinary degree of community exposure and prejudice. Second, under Reamer versus U.S., the interference with the jury process by an officer of this court is deemed presumptively prejudicial and cannot be measured by any voir dire. Ultimately, the decision to change venue lies within the sound discretion of the trial court, providing that a showing of actual juror prejudice is made. This ruling rests on 4 grounds. First, the exceptional rate of juror disqualification during the January 23 jury selection. Second, the community prejudice arising from the size of the county and the long-standing association between the defendant's family and the 14th Circuit. Third, the South Carolina Supreme Court's determination that the former Colleton County Clerk of Court improperly influenced the jury, depriving the defendant of his constitutional right to an impartial jury. And fourth, the form of publicity surrounding this case. There's case law that says I can't transfer something just for publicity. You know, that can be cured. But with the 4 grounds that I've just stated, I am transferring it. Further, this ruling is supported by the court's recent order in Beach v. Parker that I just read yesterday that Judge Kelly was interested in his order. I did go read it. There, the court found that the moving party made an affirmative showing that a fair and impartial trial could not be had in Hampton County due to the extraordinary pretrial publicity and the surrounding litigation. The court concluded, other than publicity, the settlement of the wrongful death action, the criminal prosecution of Mr. Murdaugh, the defendant in this case, including his reversal by the clerk of court. The same publicity and public attention that justified transfer in Beach is present here and further supports this court's determination of a change of venue is necessary to protect the defendant's constitutional rights. Further, I'm going to find that under Section 172185 is not an adequate alternative. That procedure would require Colleton County to bear the substantial cost of transporting, housing, feeding, and securing an out-of-county jury throughout a multi-week trial. More importantly, it would not remedy the prejudice identified by this court or eliminate the concerns arising from retrying this case in the same community where the constitutional violation occurred. I find that there's no lesser remedy that will adequately protect the defendant's constitutional right to a fair and impartial jury. The court rules venue is transferred outside of the 14th Circuit. I'm going to reserve my ruling to the specific county in which this matter will be transferred. You know, let me tell y'all, it takes a village to get this case transferred. For those of you who don't know, there's a lot of other things besides walking into a courthouse and sitting down and trying to try a case. You know, we have to consider security, transportation. Is a courthouse adequate? Is there lodging? There's also docket considerations that have already been set for next year. There's a bunch of matters to consider. So what I'm going to do is I will think about it. I need to look at it. I will tell you, Mr. Waters, you are correct. Cost is a concern because Colleton County does bear the cost of the retrial in this case. Colleton County is not a rich county. It's a poor county. So that will be at the foremost of my thoughts when I transfer this case. I was in hopes that the two of y'all could agree on a destination, but since that's not happening, I will decide and I will let y'all know. I will issue an order. I will do a formal order on my transfer of venue and also will designate the county into which we are going to try this case. Okay? Any objections?
None from state, Your Honor.
Perfect.
Thank you, Your Honor.
You're welcome. All right. Now, the last motion, Mr. McCullough, I know you've been sitting here since 10 o'clock. If you could come up and just for the record, state your position. I believe I've got, Mr. Waters, I believe I have your stance on this, but I'll get you to put it on the record and let me rule, please. Go ahead, Mr. McCullough.
Your Honor, the benches are hard and life is short, but I wouldn't have missed the Charleston travel log for anything.
I wish I would have. Go ahead.
Your Honor, I don't want to detail I'm here representing Myra Crosby, a former deposed jury familiar with, and given your nature of preparation, I know you've read my initial filings. If you have any qualms about how this matter comes before you, I will simply saying that following the plea of Ms. Hill in December of 2025, during that proceeding, Solicitor Hubbard, who was placed in charge of the investigation for jury tampering, indicated the case was closed, no charges would be filed. From that point, shortly, several months after that, in March and then again in May, we filed Freedom of Information requests for the jury tampering investigations, which were closed and therefore no longer susceptible to any exception under the Freedom of Information Act. And we sent that to SLED, the Attorney General's office, and to Mr. Hubbard's office, Solicitor Hubbard's office. In response to that motion, I think it is correct, and I don't want to preempt, but Mr. Waters is here, General Counsel for SLED is here, and I spoke to Solicitor Hubbard outside to just confirm their positions are not in opposition to the remedial attention to the protective order, but they do say that they all three, as agencies, are constrained by a protective order, which includes at least, if not is, the protective order of Justice Toll from January of 2024, issued preceding her new trial motion hearing. At that time, she issued a protective order, which I think the primary concern was to protect the identity of the jurors in the case that may have been to some extent interviewed in whatever jury tampering investigation led up to that point, January 24, and of course that investigation continued after that hearing, after January 24. So we are simply asking, and there was no other way to get here, Your Honor. We originally filed a motion to intervene, to have a court review the protective order to determine that those issues were now moot, and at least the issues that Justice Toll addressed, or the reason, as I read her protective order, for constraining any release of investigative materials relative to jury tampering. Now, there's been a little confusion. The in-camera proceedings, I am not seeking the release of, because I have that, but I am constrained by the order of Judge Newman. I was allowed to have them, but I can't disseminate them. I'm good with that, and I don't think those aren't the issue today. So I wanted to eliminate that confusion. I'm here today simply asking, Your Honor, pursuant to the Freedom of Information, and you know, the purpose of the FOI is to simply make it possible for citizens and their representatives to learn and review the activities of their government. And secondarily, Ms. Crosby asked me to pursue this because she wants to see the quality of the investigation. She wants to evaluate it. She believes the public should be able to evaluate it. She is hopeful that it will lead to additional information in support of her belief that she was targeted through an orchestrated effort to remove her from the jury. So for all those reasons, Your Honor, I believe that it's appropriate for me to be before you as the assigned judge for all things Murdaugh, and to ask you to review that protective order and any others that could be referenced that I'm not aware of, and to conclude.
You're not asking for any jurors' names or any
I'm
kind of
not, Your Honor,
identity?
but that's the worst kept secret on the planet. I think that half of the jurors went to New York and appeared on the Today Show, I think.
Well, I understand all that, but
I'm
you understand
not
as a
opposed to the
court,
redactions.
as a court, you know, we protect our jurors. Now, whether they want to get out and go dance on ABC and tell them everybody who they are, that's fine.
Your Honor,
But I'm not comfortable in unsealing any identifying factors for a juror or a juror's name.
not asking for that, Your Honor. And
Okay, just wanted to make sure.
I respect the position of the Attorney General's office, which actually filed the only responsive pleading. So I respect that. My only concern is simply this. When you begin redactions, I do not want to have to be back here or through the Freedom of Information and a lawsuit complaining about Epstein proportionate redactions. Protecting the identity is one thing, but I don't want to get pages and pages of blacked out, redacted.
I understand.
So that's our position.
Okay, Mr. Waters?
Thank you, Your Honor. First of all, as we detail in our response, there were multiple protective orders during the course of this.
Right.
And of course, the first thing we have to talk about is what you just recognized, is that the court promised those jurors over and over again, both Judge Newman and Justice Toll, we're not going to release your identity. And we deal with this all the time. Just because I might be subject to state grand jury secrecy doesn't mean somebody who's subpoenaed can't go run their mouth about it. And I still can't run my mouth about it, right? Except as necessary in court. So, and so the other thing is that we also wanted to protect, of course, ongoing investigations, which have resolved at this point. And so that's why we have filed a motion to unseal. However, our motion to unseal also includes the sealed portion of the initial inquiry that got that juror kicked off the jury, okay? And that's important that that come out. In fact, I find it interesting how Mr. McCullough says he wants the public to judge what happened, but he doesn't want them to see what was the basis for the exclusion in the first place. And so there is, that needs to be unsealed at this point now. There's no reason to do that. Of course, redacting identities. And that, of course, is the only limitation that we have, is that those juror identities be redacted. The main difficulty in that is there are some MOIs. Those are easily redacted, and other personal identifying information that are normally redacted to protect people's privacy. The MOIs are going to be easy to do that, memorandums of interview, but they are summary documents only, and there were of course body cams of interviews and that sort of thing, and so that's going to be a little bit more difficult and it's going to take some time to do, but subject only to that, to honor the court and frankly the state's promise that we won't be the ones to release your identities. We believe that not only should the sealed inquiry at trial be released, but also within the appropriate bounds of FOIA and subject to redaction, the investigative file as well.
Okay.
No, I would only respond by saying that with regard to the in-camera proceedings, we're not asking for that to be unsealed. I find it fascinating that the Attorney General's office is. I don't know how you're going to redact the identity of the person that everybody in the universe knows was the object of the in-camera proceedings and the only person who was removed from the jury. But I certainly will respect your ruling.
Well, if someone else decided to run their mouth and go to the media, then that's on them and ain't on us. I would also point out, Your Honor, that Mr. McCullough on June 24th, June of 2024, requested unsealing of the in-camera proceedings, and then filed on September 4th, 2024, a petition to intervene with the Supreme Court to seek it unsealed. So on multiple occasions, he has requested to have it unsealed. So,
and I achieved my goal, which was to have access.
Look, I like for everybody to know everything. So this is the deal. We're going to unseal it. We're going to protect the jurors' names. I want that redacted. I want any identifying information concerning a juror redacted. Unseal the rest of it.
Thank you, Your Honor.
that's exactly what the state wants. Thank you, Judge.
Thank you. All right, now with all that done, Let's talk about when we shall meet again. Already, yes. I'm telling you, I'm keeping us on schedule. We're gonna get this done. My 2 dates for my next hearing, and let me just tell, the lawyers this. I did have a motion to exclude evidence, and the state's motion to admit, evidence of motive, and that's gonna involve the financial, transactions. I think a ruling at this time would be way too premature. I want to be closer to trial. I probably will not even consider those motions, until the beginning of next year when we start doing pretrials. However, Mr. Harpootlian, your motion to dismiss, I was told I would be getting a supporting memorandum, which I do not have. I pushed that out because the state hasn't been able to respond to it, because they haven't been afforded the opportunity. They don't have it. I will push that out to the next pretrial hearing. I do not want the DNA, Mr. Griffin, to wait that long. Because I'm thinking either November the 13th or November the 20th. That would be here in Lexington, again at 10 o'clock. That way I can address any other matters that might come up. Any of those, do those dates work for y'all? I know it's close to Thanksgiving, but I was trying to get it in so I won't bother you over Christmas, because I'm gonna start bothering y'all again in January.
The 13th would be far preferable to us, so I can have all my staff available and everything for that.
Okay. How about you, Mr. Harpootlian?
What was the first date, Your Honor?
The 13th, November.
November, well, okay, let me look. It's the wrong month. Friday, that's a Friday.
The 13th?
Yep. Friday.
Oh, gosh, is it really Friday?
That's
Well, I
perfect,
didn't
Your
mean to
Honor.
do that.
That's perfect, actually.
The way things gone, that's our lucky day. That'll be fine.
Okay. Oh, that's too funny. I'm sorry. I did not realize that was Friday the 13th, but I'm not superstitious. I hope you're not. All right, November the 13th, 10 a.m. is going to be our next pretrial. We will take up your motion to dismiss. Please have your memorandum filed timely. Let me say timely, because I was working the weekend. I get 18 motions at 5:15 on the 7th. That was fine. Then I've been getting motions all week long, and that's fine too. I understand y'all are busy and you have stuff to do, and but please try to be timely. So I'm going to tell you before you say that, Mr. Harpootlian. Let me see what happened. Deadline, the Friday before. 11/7, it's gonna end on a 7. All motions that you would like for me to hear that day, please have them filed.
Your Honor, may I make an inquiry?
You may.
The problem this week for, I think, us and the Attorney General is we filed a bunch of stuff, motions last Friday.
And we got
And
responses.
we had to do responses. So if perhaps you would
Set it up?
maybe move back a week
Sure.
for the motions, and then give us a week to respond, and then if you want to file some sort of reply, do it at your own risk.
All right, how about October the 30th, which is a Friday? It's the day before Halloween.
Yeah, Halloween and Friday the 13th at this point.
Well, why not?
Why not?
Just to have your motions in, then y'all can respond the following week, and I'm putting my deadline, for the 7th. Yes, response deadline will be the 7th.
So 30th first.
File your motions,
30th.
response by the 7th. So I'll have time. I mean, believe it or not, y'all, I really do sit down and read every motion that y'all file.
Would you like us to shorten them a little bit?
Always, always. The shorter the better. But I do read all of them.
I think the 6th is actually Friday, Your
No,
Honor.
it's 11/6. 11/6. All right. Anything else from the state?
Not at this time, Your Honor.
Anything else from the defense?
No, Your Honor.
All right, Mr. Griffin, you're gonna let me know. Now, let me ask y'all about this. When he does let me know about the, DNA, because I want to be on this. It's gonna be long before November. Is it possible for us to have a quick hearing so we can decide what to do with the DNA?
Sure. Yes, Your Honor.
Absolutely, and again, once we get that, I'm happy to
It's
work
hard
with
for
them.
me to set a date until I hear from Mr. Griffin, but maybe we could set a date, and once he calls me, and I'll email y'all a few dates, and maybe we can have a quick hearing one Friday afternoon or something.
Your Honor,
Go ahead.
you know, we need the transfer of the material from SLED Lab to Othram. You know, that's chain of custody, we're out of it, but nothing can happen until that transfer takes place.
Well, and I'm gonna talk with them about that, but thought that he represented to the court that they were gonna agree and not challenge Shane and accreditation issues and that sort of thing.
We're not.
And then secondly, we'll work on that,
Are
facility.
y'all gonna let me, as turnaround's fair play, are you gonna challenge any, chain of custody on him?
Not if we agree to the procedure and my scientists are okay with it, then there would be, unless, shenanigans happen somewhere.
Okay, well, let's,
Did you say shenanigans?
I did say shenanigans. But I would also add that, just to be clear, it's still the same deal that I offered, that they're gonna process in quant and then stop, and then we'll find
stop,
out
that's
what-
exactly right. You understand that, Mr. Griffin?
Absolutely, and we're coming back to the court.
I'm gonna put it all in one place,
Right.
let you process it, then you're gonna contact the court. You're stopping, you're not doing any test
Correct.
until we know. And we're gonna have a hearing on it, a quick hearing, it won't take long. You can tell us, is there gonna be enough reserve for the state?
Correct. I just want to be clear, we're talking about the unprocessed material.
Unprocessed and the leftover is going.
It's going, but can we go ahead and test the leftover?
We're okay with that, Your Honor. They can run the leftovers. It's the unprocessed that we need the results on.
Okay, you don't need both of them to do the test?
I'll talk to the lab, I'll talk to Dr. Middleman, so I'll find out, but, we want to get this thing going.
Okay, well, I'm just telling you, before you do any test whatsoever, we're gonna have a hearing.
Okay, we won't do any testing.
Oh, we're gonna do
Just
quant.
go ahead, get it quantitative.
And I guess one last thing I would ask is that by doing this procedure, they're waiving any claim under the Preservation of Evidence Act, at least as to these items.
Well, I mean, we have to, because if it's destroyed during it, I don't find that to be a willful. I read the Preservation Act, and I don't think us doing this is in anything intentionally on either side to destroy any evidence, which, you're obligated to uphold. I don't see that, so, the court doesn't find that to be a problem. I mean, if it gets destroyed, y'all understand it's destroyed. Okay, all right. Thank y'all.
Thank you, Your Honor.
Court's adjourned.
Thank you, Your Honor.
ever need to doubt it, I'll make you so sure about it. God only knows what I'd be without you. If you should ever leave me, well, life would still go on, believe me. The world could show nothing to me, so what good would living do me? God only knows what I'd be without you. God only knows what I'd be without you. If you should ever leave me, the life would still go on, believe me. The world could show nothing to me, so what good would living do me? God only knows what I'd be without you. God only knows what I'd be without. 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 God only knows what I'd be without.
Heavenly shades of night are falling. It's twilight time. Out of the mist your voice is calling. 'Tis twilight time. When purple-colored curtains mark the end of day, I'll hear you, my dear, at twilight time. Deepening shadows gather splendor as day is done. Fingers of night will soon surrender the setting sun. I count the moments, darling, till you're here with me. Together at last at twilight time. Here in the afterglow of day, we keep our rendezvous beneath the blue air. In the sweet and same old way, I fall in love again as I did then. Deep in the dark, your kiss will thrill me like days of old, lighting the spark of love that fills me with dreams untold. Each day I pray for evening just to be with you. Together at last at twilight time. Here in the afterglow of day, we keep our rendezvous beneath the blue. Here in the sweet and same old way, I fall in love again as I did then. Deep in the dark, your kiss will thrill me like days of old, lighting the spark of love that fills me with dreams untold. Each day I pray for evening just to be with you. Together at last at twilight time. Together at last at twilight time.
Seems she forgot all about the library like she told her old man now. And with the radio blasting goes cruising just as fast as she can now. And she'll have fun, fun, fun till her daddy takes a T-bird away. Fun, fun, fun till her daddy takes a T-bird away. Girls can't stand her 'cause she walks, looks and drives like an ace. You walk like an ace now, you walk like an ace. She makes the Indy 500 look like a Roman chariot race. Like an ace now, you look like an ace. A lot of guys try to catch her, but she leads them on a wild goose chase. Like an ace now, you drive like an ace. She'll have fun, fun, fun till her daddy takes a T-bird away. Fun, fun, fun till her daddy takes a T-bird away. Well, you knew all along that your dad was getting wise to you now. Now you shouldn't have lied. And since he took your set of keys, you've been thinking that your fun is all through. You shouldn't have lied. Now you shouldn't have lied. But you can come along with me 'cause we got a lot of things to do now. Now you shouldn't have lied. And we'll have fun, fun, fun. Now that daddy took the T-bird away. Fun, fun, fun. Now that daddy took the T-bird away. Fun, fun, fun. Now that daddy took the T-bird away. Fun, fun, fun. Now that daddy took the T-bird away. Fun, fun. Now that daddy took the T-bird away. Fun, fun. Now that daddy took the T-bird away. Fun, fun. Now that daddy took the T-bird away. Fun, fun. Now that daddy took the T-bird away. Fun, fun. Now that daddy took the T-bird away. I get around, yeah, get around, round, round. I get around, I get around, round, round. I get around, get around, round, round. I get around, get around, round, round. I get around, get around, round, round. I get around. I'm getting bugged driving up and down the same old strip. I gotta find a new place where the kids are hip. My buddies and me, you're getting real well known. Yeah, the bad guys know us and they leave us alone. I get around, round, round, round. I get around, get around, round, round. I get around, get around, round, round. I get around, get around, round, round. I get around, I get around, get around, round, round. We always take my car 'cause it's never been beat. And we've never missed yet with the girls we meet. None of the guys go steady 'cause it wouldn't be right to leave your best girl home on a Saturday night. I get around, round, round, round. I get around, get around, round, round. I get around, get around, round, round. I get around, get around, round, round. I get around, I get around. Round, round, get around. I get around, yeah, get around, round, round. I get around, 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 get around, round, round. I get
Deep down in Louisiana, close to New Orleans, way back up in the woods among the evergreens, there stood a log cabin made of earth and wood, where lived a country boy named Johnny B. Good, who never ever learned to read or write so well, but he could play a guitar just like a ringing a bell. Go, go! Go, Johnny, go, go! Go, Johnny, go, go! Go, Johnny, go, go! Go, Johnny, go, go!
Ladies and gentlemen, please welcome to the stage Rabbi Eli Weinstock as he leads us in prayer.
Please rise if you are able. Our God and God of all humanity, we gather today with gratitude for the blessings of this great nation, gratitude for the freedom to gather together, and gratitude for the men and women who dedicate their lives protecting us, serving us, and keeping our community safe. Here we give thanks especially for the courage, sacrifice, and commitment of the brave men and women of the Nassau County Police Department. Our first responders who run toward danger when others are running away. We are grateful for the leadership of County Executive Bruce Blakeman, Commissioner Patrick Ryder, and the entire leadership of the Nassau County Police Department. Lord, may you give them and all who serve the public the ability to serve with courage and compassion. We ask your blessing upon President Trump as he leads our nation. Grant him wisdom, clarity of vision, and strength. Help him and all our elected officials to formulate policies, make statements, and take action that will allow Americans and all humanity to live in a world of safety, blessing, freedom, and peace, and lead America to ever greater heights. Lord, defend our nation from those who seek to harm us. Help us build a country in which all people of all backgrounds and faiths can live together with mutual respect and a common sense of purpose. Lord, bring us closer together, for when we stand together, we are stronger. In just 1 month, Jews will celebrate Rosh Hashanah, the Jewish New Year and the birthday of the world. We will sound the shofar, a piercing clarion call for all humanity. Wake up, be better, do more, serve more, care more, and never ever become complacent about the world we have been entrusted to protect. May the day come when the words of the prophets be fulfilled, that no nation will rise up against another. We will learn to live in peace. People will turn their swords into plowshares. And when all humanity recognizes that we are ultimately one family under God. May God bless us all, and may God bless the United States of America. Amen.
Ladies and gentlemen, please welcome to the stage Madeline Brame as she leads us in the Pledge of Allegiance.
We praise God and thank God for us being here today. Can we all stand and place our hand over our heart for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ladies and gentlemen, please welcome to the stage Nicole Thumhart to sing our national anthem.
Oh, say, can you see by the dawn's early light what so